So good afternoon, everyone. Thank you very much for taking the time to join this RUA California Fair Claims Handling training. As most of you will probably be aware, this is part of our ongoing series of RUA training sessions. There's a number of these during the year on a range of different topics. The regular sessions that we have include SCAP, competition law, and then, of course, this California Fair Claims Handling training. And we're really pleased that we are joined again by our expert speakers. We have Andrea Best and Alex Spisak of MWE. Thank you both very much for taking the time to join us. And Andrea and Alex will be essentially taking us through the next 90 minutes towards certification. Obviously, the much needed certificate for all of you, wherever you are, but handling claims in California. Now, before I hand over to Andrea and Alex, we have a couple of bits of housekeeping to pick up. So the first is to say that you are very welcome to get engaged in this session with the Q&A function. Hopefully, you've already found that within the platform. So at any point during the session, if something comes to mind and you'd like to pass on a question, please feel free to do so. So Andrea, Alex, and myself will be paying attention and make sure we can build in the interactivity at every opportunity. And then you might have already noticed that we are recording the session. Now, the recording is only for all of you to watch back if you have points that you want to re-reference, anything that you want to go over. So unfortunately, somebody watching the recording after the event isn't able to get a copy of the certificate, or their own certificate, I should say. It would only be for attendees actually watching it at the time now. What we'll be sending alongside the recording is a copy of the slides in PDF format, so do keep a lookout for those as well. And both of the slides and the recording will probably be sent out about a week after the session. Now, if you are dialing into this session by phone rather than joining via the Zoom webinar platform, you will just need to email the RUA's events manager, Deborah Finch, to let her know that you've done so. This is just so that we can identify that you've joined the call and make sure that you receive your certificate. So Deborah's details, hopefully you've already received a couple of emails from her, but it's deborah.finch@rua.co.uk. Now, we as RUA, we will supply the certificates working with Andrea and Alex, and that will be over the next couple of weeks. Any questions after that period has passed, please let Deb know. So with that, I think that's the various points of housekeeping complete. I think we can get started with the session. So Andrea and Alex, thank you again for joining us, and I'll pass over to you and we can get started.
Thanks very much, Tom. Happy to be here, happy to help. And I know, of course, for everyone in the audience, this is the highlight of your year. I'm joking, of course. I know everyone's here because you have to be. So with that said, we'll try and keep the boredom to a minimum. I know you all know that California requires anyone who is involved in the handling of California fair claims, including for non-admitted insurers in this market, to have this training session. Just by way of background for anyone who doesn't know me, I am based in the London office of McDermott Will Emery, an insurance partner, head of our regulatory practice here in London. But I am a U.S. lawyer primarily, and focused on U.S. insurance regulation, such as the topics covered here. And so I come at it more from the perspective of how these kinds of issues, arise in regulatory complaints. My colleague Alex is based in the U.S. and has worked in California and has seen firsthand how the Californian, how these Californian regulations might arise in the context of an insurance dispute. So hopefully, with those two perspectives, we can help to show you how these might arise in practice. And with that said, I will get started with the actual slides. There we go. So just to give an overview of the topics that we'll be going over. So obviously introduction, applicability of the claims laws. So to what kinds of insurers do they apply and what kinds of claims, the required training, record keeping requirements for insurers and brokers and TPAs, deadline for any actions or communications to insureds, the settlement rules when you're in the process of actually settling a claim, special rules for certain lines of business, and finally, the favorite section, penalties, where we try to scare you. With that said, here we go. So a few considerations here for context in terms of, I know, as I said, we're looking through these laws because it's a requirement for anyone who's involved in this, but just to understand the practical perspective of the regulators. Obviously, there have been wildfires for quite a few years there, every year in a row, and continuing in this year. We have, according to the California Fire Department website, as of last night, 769 wildfires in 2024 so far. And of course, with that, there's a special scrutiny by regulators on how insurers are handling claims from victims of these wildfires. And as well, this was a couple of years ago. 2022 was an election year. California is one of, I believe, 11 states where the insurance commissioner is actually elected. And one of the challengers to the current commissioner had asserted that he was not doing enough on wildfires and is too favorable to industry. So of course, that means that the regulators now are very much focused on trying to show that that is not the case and that they are supporting their constituents. And the department, of course, continues to issue press releases in this regard, and there is sometimes litigation over very high alleged penalties, leading to momentum for claims handling, complaints, and reviews of insurer activity. The state budget in California has been for many years in deficit, so that's ongoing, which leads, of course, as with any regulator, really, when there's if there is an enforcement activity going on, if there's an investigation, I should say, that begins, then that tends to lead to regulatory personnel trying to maximize penalties once they have spent the resources to investigate a particular allegation. So just to set the scene there, and of course, as I mentioned above, the ongoing focus on consumer protection when you have a state where the insurance commissioner is elected.
Andrea, if I could add one thing here, the only other consideration I would put out there too is California's having real whiplash with climate change and everything going on. You're seeing these wildfires being followed by incredible wave after wave of atmospheric rivers. So in addition to wildfire claims, you're going to see weather-related claims from floods and otherwise. That I think you're going to see a similar focus on those flood claims and other home damage in that type of area to just be aware of as well.
Yes, that's a very good point, Alex, actually. Thank you. Okay. So just this next slide here, just to put into context. So this is from a survey of insurers, U.S. insurers' market conduct enforcement actions. And it's a little bit stale because it's from 2021, but wasn't published until the end of 2022. He did not publish another one in 2023 because it's basically now part of a separate service that is no longer available to the public, and is behind a paywall. But in general, I think these principles are still the same that are driving market conduct enforcement actions in the U.S. And I should say as well that while not in California specifically, but we have seen Florida over the past year begin to perform market conduct investigations of surplus lines insurers, including specifically surplus lines insurers in this market. And so that's and I should add that's following hurricane events to specifically look at their claims handling practices, and that might be something that we could see spread to other states. So obviously, for in addition to just for the reasons that you normally would. You of course want to comply with all the requirements and treat your customers fairly, but also just be aware that it's possible that regulators might come afterwards and say, okay, we want to see 100 of your claims files and give us everything because we want to review exactly what was said, when, to who, and and why did you reach the resolution that you did. Pardon me. And with that said, so these are some in the top 10 reasons that regulators have found insurers lacking in market conduct surveys that are related to claims. So one is failure to acknowledge, pay, investigate, or deny claims within specified timeframes, failure to provide required compliant notices and disclosures in claims processing, failure to process total loss claims properly, failure to issue correct payments and or compliant denial notices, and improper or incomplete documentation of claims files. Now, applicability of the regulations. So as I mentioned before, they do apply to insurers operating in this market, including surplus lines insurers, expressly by the terms of their regulations, which is not the case in any other state that training is specifically required for surplus lines insurers handling claims. But there are certain types of insurance exempted. One is workers' comp, which has its own set of regulations, but again, cannot be written by insurers in this market anyway. So that's somewhat of a moot point. But also healthcare provider professional malpractice liability, and self-insured or self-funded ERISA plans. Surety also continues to be treated separately and have its own separate rules, which we'll mention at the end. Medical malpractice is no longer excluded, other than as above, as of 2021, and home protection contracts, which you may think of extended home warranties or service contracts. California is one of the states that regulates those almost as insurance, and so they now are included under the regulations as of a few years ago. Again, in terms of applicability, there obviously must be a California nexus in order for these rules to apply. The policy has to be issued to California residents, meaning either individuals or a corporation that is based in California, or the claimant is from California, so the policy could have been issued elsewhere, or the subject of the claim is located in California, such as obviously a car crash or something like that occurred in California, or some cargo that was being transported through California, and the claim was investigated there. It applies to all persons who adjust California claims, settle California claims, or investigate them, which includes all activities of an insurer or its claims agent related to the determination of coverage, liabilities, or loss or damage. And finally, portions of the rules also apply to insurance producers and admitted insurers. Not that we'll focus on that too much, but those are referred to as licensees, claims agents of insurers, and then, of course, insurers, which includes non-admitted carriers. And forgive me because the slide numbers are not showing up for me. Alex, have we reached the slide where you would be taking over? I don't want to.
Two more.
Two more. Okay, thank you. I just didn't want to step on your toes there. So for the, pardon me, just got a phone call. So California Department of Insurance view in terms of the jurisdictional issues, what is the view of the regulators? They believe that the regulations apply to all insurers, both admitted and non-admitted. Historically, the department indirectly regulated non-admitted insurers through what was called the LESLI, the list of surplus lines insurers, eligible surplus lines insurers. And if you didn't comply, then the California department would simply remove an insurer from the Leslie and say, okay, you can't write surplus lines insurance in my state anymore. But when federal law changed in 2011, as a result of the Non-Admitted and Reinsurance Reform Act, which basically said that all non-US or alien surplus lines insurers are eligible by virtue of appearing on the NAIC's quarterly listing of alien insurers, California replaced their Leslie with what is now called the LASLI, a voluntary list of approved surplus lines insurers. So technically, California doesn't have the right to prohibit insurers necessarily, they don't have the right to say, okay, we can kick you off our list. They can kick you off the LASLI if you're on the LASLI, but you don't have to be on the LASLI to write business in the state to begin with. However, they can still fine insurers, and an interesting development recently that some of you may be aware of is the NAIC itself has currently proposed a new plan of operation that basically governs the rules by which non-admitted insurers, alien insurers, surplus lines insurers are listed or approved. And one of the things they are now proposing to bring within their purview, which hasn't expressly been part of their remit to date, or at least not so blatantly, is market conduct matters and governance issues like that. So it is also possible, of course, that, and California, I should add, is one of the 13 states that is part of the committee at the NAIC that reviews and determines which non-US insurers get listed by the NAIC. So I think, you know, a market conduct issue in California due to failing to comply with the claims handling regulations could, obviously, in an extreme circumstance, lead the NAIC to take action as well, which of course would affect insurers' ability to do business throughout the states. Again, I think that's sort of very much worst case scenario, but it's just important to keep in mind how, from a practical perspective, these can reach overseas. And now I think are we at your slide, Alex, or have I still one more? I'm trying to finish as soon as possible, obviously. No, sorry, I don't know why the slide numbers aren't showing up in this view, but with the training requirements, why are we here? All insurers, including non-admitted insurers, must adopt and communicate to their agents or claims agents the written standards for the prompt investigation and processing of claims. And that also means that also individual licensees and TPAs, or other third-party loss adjusters, must annually certify that they have read and understand the regulations. Entity licensees, so in other words, a company, a business entity that holds a license, must either provide training to their claims agents and certify annually to having done such training, or obtain a certificate from independent adjusters that they have been trained. And the annual certification should be completed by September 1st of each year and maintained indefinitely. So you're all ahead of the game by doing your training in May. And I should add, the IUA, of course, has kindly agreed to, as Tom mentioned, to provide copies of the certificate to all of you who are attending today. So you will receive that by email as proof that you've complied with the regulations. And with that, I think we are actually at your slide.
Now it's my turn. Yes. So the general standards here you want to kind of keep in mind and then apply. As it says here, insurers must adopt and communicate written standards to the claims agents. The licensees must have a thorough knowledge of the regulations, provide thorough and adequate training to all claims handling employees and representatives, and claims agents must promptly and correctly investigate and handle claims. I think kind of the big three takeaways here is, one, to keep everything in writing and documented, know and understand the regulations. That's why you're here today, to kind of learn a little bit more about them. And three is, do not delay claims handling. You go next slide, please, Andrea. So the four areas the California Department of Insurance is really focusing on is faulty documentation, which is often the absence of communications, letters, notes, work papers, other things that kind of speak to what the claims adjusters did or what you did as part of the claims. Again, keep everything in writing. That's a point that's going to come up again and again. The second area of focus is improper handling. So things such as failure to explain all the benefits and coverages available under a policy, not following certain time limits that might apply, or asking and seeking for information that really isn't required or material to resolving a claim dispute. This kind of falls under that do not delay bucket. Third are improper delays in responding to communications from a claimant or sending notices and beginning investigations. Again, do not delay. The CDI wants prompt investigation, prompt resolution where possible, and taking longer to get there does not look good to the CDI. Excuse me, CDI. The last point: improper handling of denied claims. So primarily, you need to state in writing the factual legal basis for such denial and telling the claimants they can appeal. Again, this falls into the keep everything in writing, all communication in writing. Next slide, please, Andrea. So record keeping. There are requirements to retain everything for 5 years. It may be electronic if they can be duplicated to hard copy. I know now most claim files are electronically stored and kept, so long as those documents are able to be transitioned to a PDF and printed, however it might be, that's acceptable. Very rarely do I get a claim file anymore in the litigation where it's not some sort of electronically stored device, and that's perfectly fine so long as it can be printed. The record keeping, the documents must be accessible, legible, retrievable, and there are exceptions for catastrophes. That's kind of an amorphous term. What satisfies what a catastrophe is going to be very fact specific, but I know everyone tends to have backups on their data and information, and as a best practice, that's what you all should be doing. But there are obviously situations where out of our control. And the claims file must contain all the relevant information. So records, documents, work papers, correspondence, any notes, including the substance of all phone conversations. And you want to be able to recreate a timeline of events of what happened from the incident or event through the claims handling process. Again, I sound like a broken record, but documenting and papering the file is extremely important. It helps me in the litigation realm where I'm trying to understand what happened, representing in front of in court or in front of a regulator. The more information that can be kept, more detailed information that's available, the better.
And to that end, I would add that it is very, very typical for the California Department to request copies of the claims file log anytime that they receive a complaint from an insured or a claimant, and they're trying to determine, what they're trying to determine what happened. And if you don't provide the complete claims file log, they do tend to call you up on it, including insurers in this market, and say, thank you very much for your response, but you didn't give me X, Y, Z, and therefore your response is deficient in the following ways, and the complaint is justified against you. So that's, again, another reason it's important to, even if you're not the one submitting a response to the regulator, or obviously appreciate that from this market, you'll have third parties on the ground in California who are doing all of this for you. It's important to make sure that you emphasize to them, and again, they should obviously be sitting through these trainings too, but to make sure that you say, hey, if you're putting the response together for us, make sure you have all this information, or make sure you give us all of this information, make sure you're keeping all of this information. So, sorry, back to you, Alex.
Fully agreed, Andrea. Yep. Next slide, please.
Yep.
So the initial interaction, you receive a claim, you receive whatever instance of communication from an insured or from a claimant. So you must properly and fully represent the policies to the insureds, and it's just, you have to be upfront about it. There's no hiding the ball. There's no trying to dance around what the policy says. You must disclose. So even if they're not asked for, you must disclose to all first party claimants all the benefits, the coverages, the time limits, or other provisions that may apply. The key here is full disclosure. And lastly, you need to conduct a thorough search for all applicable policies that may respond to a claim. So just because you hear from an insured or a claimant under one policy, you need to go back and check to make sure there aren't other policies issued to this insured that may also respond for coverage. Just because they didn't seek coverage under one doesn't mean that coverage doesn't exist, and you need to go check to make sure there isn't other potential coverage out there. So next slide, Andrew. Excuse me. So notice of release and waiver. If the applicant is not represented by an attorney, it's known as pro se, and you seek a release beyond the subject matter of the claim, you must give a written explanation. California courts take this very, very, very seriously. They will not allow a blanket wide waiver release without clear evidence that the unrepresented individual was aware of what they were releasing. A lot of cases out there about this subject. It's been heavily litigated, heavily addressed, and California courts do not take kindly to insurers who do not follow these rules. So best practice, explanation needs to be clear and conspicuous. Written explanation, regardless of whether you think the claim is represented by an attorney. So when in doubt, always just give the written explanation about all the claims that may be waived, and make sure you kind of cross your T's and dot your I's here. As you see, the verbatim text as of 2024 is a general release, does not extend to claims that the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release. And that if it was known by him or her, it would have materially affected his or her settlement with the debtor or release party. So deadlines. These another place we talked about earlier. The CDI is very focused on making sure insurers follow these deadlines and keep to them. So there's an immediate 15-day rule where immediately transmit notice of claim to the insurer. The insurer needs to advise the insured that they've done so, and immediately, but not later than 15 days of the notice after a claim, acknowledge receipt or pay the claim, accept disability policies. And when in doubt, always copy the insurer. And these may be in phone or in writing, but again, paper the file, keep it in writing to make sure that it's easier to recreate those timelines. When the CDI comes asking questions, you have emails, letters, correspondence, whatever it might be, that shows the deadlines were followed and how they were followed.
And I should add, these are, of course, these would be the rules that apply on the ground to the adjuster or broker who's receiving the notice of claim. So that's why the obligation is on transmitting it immediately to the insurer. Tell the insured that you did that, but so that so you guys know this is what people are, the agents downstream from you, shall we say, are required to be doing, and how quickly they have to notify both you and the insured, and that you want to make sure to the extent you can that they're doing that.
Thank you, Andrea. It's an important clarification I was not very clear about.
Yeah, no, I didn't say to be go ahead.
And again, provide all necessary forms, instruction, and assistance as the claims are investigated and things are ongoing. Next slide. Thank you. So statutory requirement 790.034. So within 15 days of a notice of a claim, you must provide the following: copy of the California Insurance Code and at least a 10-point font. Excuse me. And in addition to the California Code, Fair Claims Settlement Practice regulations govern how insurance claims must be processed in the state. These regulations are available. It has a website and additional information. So that needs to be provided to the claimant so they can understand the process a little bit, go find more information if they seek, and where they can kind of go for help. Next slide, Andrea. So the exceptions to the deadline for response to a notice: perhaps extraordinary circumstances beyond your control would severely materially affect the company's ability to conduct normal operations. So, you know, pick your fact pattern there where something truly catastrophic might have occurred that could delay this. Again, these are going to be factually based kind of scenarios that come up. There's no hard, fast rule of what is an extraordinary circumstance, but you can imagine what might occur to kind of cause that. The other is a notice of legal action by the claimant. So obviously, if the claimant is suing the insurer, the deadlines are kind of told as that has now shifted to a very different posture. Next slide, please, Andrea. So a notice of a claim, it can be verbal unless the policy requires it to be written. It generally should include the date of loss, time of loss, place of loss, name and address of claimant and the insured, and the policy number. Just kind of the generic information you would expect to understand to start gathering the information of the claims process. Again, no deadline to submit unless there is a requirement in the policy. So notice of a claim is broadly defined. So it says any notification that reasonably apprises the insurer that the claimant wishes to make a claim. So it might not include communication for information or incident reporting purposes. So you can conservatively construe notices for underwriting, but it's kind of a best practice that if you do receive notice and it sounds like it might be claim related or an incident occurred, to kind of construe that liberally to give the notification within 15 days and ask for additional time as you continue to process, just to make sure you don't run the risk of running afoul and missing a deadline once you receive a potential claim notice. So again, it's best to err on the side of caution, and I'll say it yet again, this is where you can start papering the file. Put this information down when you receive so that you're have those deadlines started and are beginning to track the whole process. So immediately, but no later than 15 calendar days, you need to reply to communications that reasonably suggest that a response is expected. That's, you know, the claimant or other person, they're asking questions, you obviously need to respond to them. You need to provide necessary claim forms, informations, instructions, and give reasonable assistance in this process. Commence whatever investigation needs to occur. And there are the insurance code and the regulation sections that need to be provided. Again, best practice would be to provide them, but you know, if requested, you certainly need to provide them. Next slide, please. So a 21-day response rule applies to any CDI inquiries. Must respond immediately or within 21 days with a complete written response that contain the known facts, include copies of any requested documents. As Andrea alluded to earlier, these are going to be probably pretty thorough requests that all portions of need to be responded to, or you risk being deficient. And if the claim and all information is in the file, they are much easier to respond to, and you're better positioned to provide the information the CDI is looking for.
Yeah. And on that too, I would add, you know, it's quite common sometimes for claimants to provide very broad, vague complaints to the department without many facts. And so as a result, the department, when passing along that complaint to an insurer and asking the insurer to respond with their side of the story, basically, will often ask quite a lot of open-ended questions, many of which may not really be all that relevant. But California is one of those states where you do need to answer all of the questions that they've asked, provide all of the information that they have requested, because even if you have done everything properly and that many of the questions they have asked aren't really relevant to the facts at hand because they weren't really part of the dispute, it's just that the department didn't have the information to know that up front. We have seen the department say, well, the complaint against you is still justified because you didn't give me this information within 21 days. And I should say, you know, here we have this points about, request, if the request demands a shorter response time, or if the request demands a response within a longer time, whether can you rely on that or not, and saying that's technically a rule violation, even if the department says, respond to this letter within 30 days, but the regulation says 21. We have recently had the experience of requesting an extension from the department to say, we need a little bit more time to gather all the information that you've requested. Can we have an extra 10 days? And they said, thank you for letting us know. We will accept this. We will expect this late response. We'll note down that this late response will be coming in. However, we're unable to give any extensions. And so that's still a violation of the rule. So basically they were just saying, thank you for letting me know that you're not complying with the rule. So of course, that means everyone scrambled to answer within time. So most state regulators will give an extension when you ask and say, okay, yes, I understand, you need more time to gather all the information that we've requested, but California says, nope, that's a violation of our laws. So just bear that in mind if you get one of these.
Yes, a fair reminder that the regulators are not often your friend.
They said we don't have the authority to grant extensions because of this regulation. So, over to you, Alex.
It's then a 30-day response rule. So within 40 days, receipt of a proof of claim must accept or deny that claim. Any evidence or documentation, regardless of how the insurer obtained it, which provides any evidence of the claim that supports the magnitude of the amount of the loss, regardless of the source of information. So just because you didn't receive the information from a claimant, but you were able to get it, doesn't necessarily mean it needs to be excluded from consideration. So again, when in doubt, to make sure you don't run afoul of the timing, liberally construe the information from when it would start this clock. If the insurer cannot respond within 40 days, you must notify the claimant that more time is required and specify why. Each 30 days thereafter, you must provide additional notification until that decision is made. And you cannot require duplicative proofs of claim for multiple policies. So if there's a single claim, multiple policies respond to it, one proof of claim is sufficient. You can't make them submit multiple proof of claims for each policy.
And again, to that end, if you do get an inquiry from the department about a specific claim, if someone's made a complaint, then it's important to bear in mind that your response should hopefully reflect that this law was complied with, right? So that if you said, well, we haven't resolved this claim yet because we've told the insured, multiple times that, I don't know, we need a copy of its driving license or something, and they haven't sent through, or they haven't sent through the alternative estimate or whatever it is that, they said, they needed, then you need to show that, and we kept, whatever, it's been 5 months and we haven't resolved this claim because they haven't given us the information that we asked for. And here's every time that we followed up and kept asking for that, and when I say we, obviously that's likely to be the adjuster on the ground, but yeah, just hopefully that it's important to bear in mind that your response should reflect that, so that otherwise they're likely to come back and say, give me copies of your, all your communications with the insured where you requested this information. Sorry, do you need the next slide, Alex?
Next slide. Yep, sorry. So if the insurer cannot make that determination until something happens in the future, you must provide notice that the determination cannot be made until then, and then give estimates as to when you believe that event will take place. Similarly to statute of limitations. So if you're negotiating with a claimant for a settlement of a claim and the statute of limitations of law, policy, or contract is occurring, you must give 60 days notice, or as much as possible if the claim is received within that 60-day time period. The regulators and CDI in particular is not going to be happy if it seems like you are stringing things out to get over that statute of limitations time, and that will look like bad faith, which is always a scary place to be in insurance litigation. I can promise you that. There's a 30-day timeline for first-party uninsured motorist claims, and if fraud is suspected, there's a 80 days, so it's a little bit more to allow for more investigation and that type of fact-based determination. Next slide, please.